Welcome to the second video of SCL Talks. I am İdil Kurtbozoğlu. I'm one of the founding members and currently acting as the Vice President of SCL Turkey. Today's topic is notices and time bar clauses for claims. I'm very glad to say that we have Mr. Shai Jackson with us today, who is a partner at Bryan, Leighton, Paisner LLP, London, and who's also the treasurer for SCL UK. Thank you for joining us, Shai, and welcome.
Thank you for giving me the opportunity to take part. Thank you.
Before we start, as an experienced SCL representative, can I ask that you give us a bit of an advice and summarize what should be expected from SCL Turkey in short and long terms?
Well, I think that in the short term, the focus should be on making the SCL known within the industry, to lawyers, engineers, and architects, and also to form good relationships with bodies such as the engineers or contract associations in order to cooperate and increase the membership. And then in the longer term, and once lockdown is over, I think that the aim is to create a body of knowledge that is relevant to any Turkish construction professionals and to help spread that knowledge and increase the level of competence within the industry, whether this is done through talks, papers, or conferences.
Okay, turning to our topic now, what does managing a construction project mean in terms of legal support? What are the benefits of having a legal team overseeing a construction project before an actual dispute arises?
Well, I think that there are two main phases that you need to look at in terms of legal support. And first, it can help in understanding the contract, what has been negotiated, and any risk areas. I find in my experience that it is quite common for the people who negotiated the contract, are familiar with its provisions and how risk has been determined, to move on, and sometimes a different team then delivers the project, and they've been maybe less familiar with the contract or what has been negotiated. So it is very important to start with that the team that delivers the project understands the contract and understands how risk has been allocated. And then as a second phase, as the work progresses, quite often for over several years, it's useful to have in effect a helpline so that when an issue comes up, you feel comfortable just checking what is the legal position with a lawyer. And getting that advice early helps to take the correct steps and avoid mistakes, which sometimes are difficult to change at a later stage. So for example, presenting a claim on the correct basis with the full detail makes it much more likely that it will be resolved than presenting a claim which is unclear and requires additional information. Good advice at an early stage can help prevent disputes or ensure that you are better placed if a dispute escalates formally at a later stage.
Exactly. And for the notices, does a notice always mean a request for a claim, like extension of time, additional payment? Which purposes does a notice serve?
Well, notices are not just about claims. They are procedures designed to ensure that the parties communicate in relation to key issues. And it covers, for example, changes to key personnel, subcontractors being appointed, or the works being ready to be tested or handed over. And for example, advance warning notices allow the other party to take steps to mitigate the impact of any risks that come up. Mm-hmm. And you can, of course, issue notice about any other issues that are important to the parties of the project. But there are also specific areas where the contract requires a notice because the parties have decided that those are key issues. And that again allows the other party to take the necessary action. Sometimes they need to approve a subcontractor or arrange for testing or extending a bond. And of course, there are areas where there are specific time limits for issuing notices or any other requirements, and they tend to be much more relevant in relation to notices relating to claims or disputes.
You just mentioned advanced warning. I have a question that might be cultural. Prompt notice would require the notification of current matters. I can from experience say that most of the Turkish contractors will not feel at ease just with notifying particularly small-sized claims to the employers, especially at the beginning phases of a project, to keep the relations on a positive space with the employer. How would you interpret this approach?
I fully understand that issuing notices or claims can be seen as an aggressive step, and it does affect the working relationship. But I think there are two important points to bear in mind. And the first is that if this is what the contract requires, then not issuing a notice is potentially a breach of contract. And as I've mentioned before, there are time bar clauses where if you do not issue the notice correctly, or you do not issue it within the specified period, then you may lose the entitlement to additional payment or additional time. So it's very important to comply with the contract to start with. But on a practical level, what I tend to recommend is not issuing notices by surprise, but first letting the other party or perhaps letting the engineer know that a notice is being issued and explaining that this is being done because the contract requires it, because it is useful to be open. And if necessary, you can say that it is a requirement that the lawyers are insisting on. But then you can also pass across the message, if relevant, that you're still open to resolving the issue and discussing it amicably. And I think that if you do that, in addition to simply issuing a formal notice, then the reaction will be very much different.
Exactly. Like you're saying, letting the engineer know of the issue shall not be used as an alternate to a formal claim. It's just a procedure of a prior notice.
Yes, the important thing is to comply with the contractual requirements. And if a formal notice is required in a certain format within a certain time, this has to be done. But at the same time, on a less formal basis, you can tell the other side and tell them that the notice is being issued, explain that it is being done in order to comply with the contract, but that you're also keen on keeping the relationship alive and discussing how it can be resolved without it escalating unnecessarily.
That's a very good tip and very useful, Shai. Then how should we structure a notice? What are the key points that require the utmost attention?
Well, the objective is to achieve clarity. So as a minimum, you want to state that it is a notice and identify the relevant clause. And it also helps to send it separately from other correspondence. What is also very important is to check the period for notices, because if you have what is called a time bar clause, then the notice may be invalid if it is sent too late, and then you may lose your entitlement. And you should then include details of what is being notified based on what the contract requires, and in any event, what the other side will need in order to understand what the notice is about. It does not have to include every possible detail, but it should be structured clearly, and it is usually best to set out the facts chronologically. And it will ultimately depend on the type of notice that is being issued, but sometimes it is useful or necessary to add supporting information of documents, for example, cost breakdowns or a copy of the relevant program. A good test is to ask yourself, will the party receiving the notice understand what it is about, what is it trying to say, or will they have to ask for more information or an explanation?
Exactly. And now turning to the legal teams. Governing law and international experience may not follow each other. So how much of an impact does a governing law has over a standard form contract?
Well, that's a good question. All legal systems respect the contracts and what the parties agree, and parties should follow what the contract says. And in many cases, it will not make a difference. But there are areas where the governing law can make a difference, and it tends to be where there are disputes about how contractual provisions operate. So for example, under English law, liquidated damages are fixed and cannot be changed by a tribunal, but under other legal systems, a tribunal can in fact adjust delayed damages to reflect actual losses. Another example is that even within the UK, there are differences in how concurrency and delay claims is seen. And under English law, the general principle is that the contractor gets time but no money. But under Scottish law, it is possible to make an apportionment. And ultimately, sometimes it does depend on the contract. Now, when it comes to notices, the other points to bear in mind is that English law does not have a general good faith concept like many other civil law systems. So arguments about time-bound clauses or how parties behave could be decided differently, and it could also affect how notices should be sent and to which address. So it is important to check the governing law, and whether it is relevant to any notice provisions or other contractual issues.
Exactly. And Shai, what kind of a team would you advise that would work on formulating the notices?
Well, I think it depends on the type of notice and also how important it is.
Mm-hmm.
Routine notices in relation to issues such as tests or access to site can be managed by the site as long as they're comfortable that they understand what is required under the contract. In the case of notices about claims, or in particular key issues such as termination, I would recommend taking legal advice to ensure that the notice is valid and served correctly. And this is because if the notice is late or it does not have the right information, the claiming party may lose its rights. And under English law, for example, there is also the risk that an invalid notice of termination is a breach of contract, and that allows the other party to terminate and claim damages. So it is very important to get it right. And as I said before, even for simple notices, it is sometimes worth just calling a lawyer and asking for a quick check just to ensure that everything has been done properly.
Exactly. Then, Shai, what tips would you give us when we're wrapping up this video on this subject?
Well, I think it's important to certainly check what the contract says. And when you are issuing a notice, as I've said before, make sure that it says that it is a notice, it refers to the relevant clause, it is sent separately, it contains the information in a nice, clear way, and it includes any supporting documents that you need to include. And I think if you do that, then the chances that there will be dispute about the notices will be much lower.
Thank you. Thank you very much for this very fruitful information, Shai. And we hope that we can also get your support, and in light of your advice, we improve our actions and events for SCL Turkey. Thank you for so much for what have you done until now. And we will be seeing you in our third video for the SCL Talks. Thank you for now.
Thank you, and I look forward to what SCL Turkey does next.
Bye-bye. Cheers.